The Pretoria High Court is hearing arguments in a discharge application by one of the accused in the Senzo Meyiwa murder trial. Mthokoziseni Maphisa's lawyer, Zithulelo Nxumalo, has questioned the omission of crucial witnesses by the state. The state alleged that Maphisa was one of the alleged lookout men when the soccer star was shot and killed. Joining us now is legal analyst Nthabiseng Dubazana. Nthabiseng, a very good afternoon to you and thank you so much for joining us. Maybe let's try and understand and unpack Section 174. Why might an accused person consider applying for the Section 174 discharge after the prosecution has finished presenting its evidence?
Good afternoon and thank you for having me. That is the process we have to follow when it comes to criminal law. You cannot apply to be discharged before the process or the state's case has been submitted to the court. So you need to give the court reasons why there's not sufficient evidence. So Section 174 basically states that the court must give a discharge if there is no evidence. And by no evidence, it's anything that links the accused to the crime itself. So you have to wait for the state to lead its evidence and for the state to close its case. So you can point to the court contradictions, you can point to the court aspects of the case from the state that is unfortunately not incoherent or not relating to your case or to you being part of the perpetrators in the case. So this is where it has to happen at the close of the state's case.
And is this prevalent? Is it common for us to see the practice of the Section 174 application by an accused in our courts?
Every single day. If you're a defense attorney, criminal defense attorney, you don't do it, I would have a lot of questions for you. Why do you not apply it? Only when the state's evidence is so overwhelming would it be ill-advised for the representative to make an application into the Section 174. But at the end of the day, we are creatures of statute. So if you do advise your client saying there is not enough evidence for us to rely on 174, we must proceed with either opening our case or you can choose to not give any evidence whatsoever. But 174 may be ill-advised. Then if your client still says, let's proceed, then we proceed. But yeah, it is an everyday occurrence.
So we heard Advocate Nxumalo earlier on just speaking on some of the issues in which they were putting forward, saying that, in fact, Constable Zungu's testimony has nothing that implicates accused number 4. He says a bulk of it was just hearsay, also saying that the evidence does not show in any proceeds of the bank records that implicates that accused number 4 received any payment. So in the context of this particular trial, what would you say the defense needs to show in order to succeed with such a Section 174 application?
I think counsel is actually on the right track. He is following what the trajectory would be. So you need to show there's no link between the state's case and your client in any manner or form. So over and above what you just mentioned now, Katleho, there's also chain evidence, which was also mentioned that the DNA of his client was not connected. So a lot of things that were missing that were connecting his client to the crime itself. So he's going through the record sentence by sentence, paragraph by paragraph, to show the court that, listen, this witness said this, and then it was never corroborated, hence the hearsay. I think he made mention of the fact that Kelly Kumalo didn't come in and give evidence to corroborate whatever was said. And then he made mention of certain DNA evidence that comes from the hat, which was never added or linked to his client. So those are the kind of holes that he's poking into the state's case to show the court that even if you were to say that you want him to give evidence and you deny me a Section 174, already as it is, the state's case is very weak.
And if the court finds that the evidence is then not sufficient, what are the possible implications for the other co-accused?
They will proceed with the trial. They will go either one of two ways. They will either give evidence or they will choose not to open the defense case. The way things are looking, it may likely be that the defense case may not even be open because of funds more than anything else. But yeah, they have a choice to give their evidence or choose not to give evidence whatsoever, and then let the court decide on the evidence of the state.
But does it give a disadvantage to the state to say, well, if you had placed accused number 4 at the scene of the crime, then maybe what implication would this have on accused 1, 2 and 3 when you now have given Section 174 discharge to accused number 4?
Well, actually, so much case law goes against what you just said. That the state's case should be supplemented by the evidence of the accused. So the state may have such a porous case, in other words, so many holes in it. But the only way to fill in those holes is to bring the accused in to give evidence. And then the court says, no, the state has to make sure that they have a case beyond a reasonable doubt of the accused before the accused goes into the box and gives evidence. So even if the 174 was granted today, it shouldn't have an impact whatsoever on the accused persons. And if the accused persons choose not to give evidence and not open the defense case, it shouldn't be that it would be said that had you testified, we would have had a better case. No, it should be, and which is the law, which is the principle, it would work against you if the state case was so strong and you made the choice not to give evidence that could pull you out of the trenches of the state's case, and therefore now you're finding yourself in hot water.
All right, Nthabiseng Dubazana, thank you for just bringing us into some kind of perspective legally with regards to this case. Thank you for your time this afternoon.